Be seated, please. Court will come to order. And the agents may begin when they prefer, and we'll waive a recitation of the facts.
Mr. President, Your Excellencies, my name is Ian Perry. This is my co-agent, Jake Phelps. I request 13 minutes for my discussion of contention 1 and 15 minutes for my co-agent's discussion of contentions 2 and 3, with the remaining 2 minutes reserved for rebuttal. Thank you.
Right.
Lydios is asking the court to declare that Endymion cannot use a facility launched, constructed, and funded by Lydios and registered by Lydios to engage in activities that Lydios has reason to believe violate Article 9 of the Outer Space Treaty. My argument will consist of 3 parts. First, I will list what is being defended and what is not. Second, I will discuss the secondary issue of buffer zones. Third, I will spend the majority of my argument proving that jurisdiction over Fortuna and Messenger 3 remains with Lydios, and therefore the Moon Protection Act can be applied there. With regard to certain aspects of the Act, such as the reference to the Apollo sites and the reference to tourism on the surface of the Moon, we believe that the Act should be construed in accord with the practice of many systems to not contradict international law. Many systems include international law as part of their constitution, and in the United States, for example, there is a presumption against extraterritorial application of national law. If the court believes that the Act simply cannot be construed this way, we contend that it is severable. As in the Bering Sea arbitration, there was U.S. environmental law which attempted to preserve the sealing populations on the high seas. The Act was, of course, ruled valid with regard to U.S. vessels and valid with regard to U.S. territorial waters, even though it was invalid as it was applied to foreign vessels on the high seas. In the present case, however, we do defend the application of temporary buffer zones with no enforcement mechanism in immediate proximity with Lydian space objects. Now, Lydios has no authority to generally regulate foreign nationals on the Moon. Lydios has no authority to regulate nationals. Yes, Your Excellency.
Agent, if I could ask you, temporary buffer zones, and who decides the extent in area and time of that? And under what jurisdiction or what international law principle?
Your Excellency, there are many precedents for temporary buffer zones in connection with a specific activity. Obviously, the right can be abused, but there is specific precedent both with regard to the high seas and with regard to space. With regard to space, there is an exclusion zone in the immediate vicinity of the ISS. NASA has advocated, though this is not currently legally binding, buffer zones around historic sites on the Moon with regard to their scientific value. And Russia, in their national space legislation, has actually included a provision allowing for regulations with preventing interference with their own national space activities in the immediate vicinity of those activities, and contend that that is not an appropriation. This is supported by the fact that the major space powers are in a unique position to combine state practice with an opinion to be legally bound in terms of the developing law of space and in terms of establishing international customs. Being notes, Russia and the United States, and in the present context with regard to the Moon, Lydios, it appears from the facts, is the largest actor on the Moon. These 3 powers have been in the best position to establish state practice. All 3 of them agree that temporary buffer zones are acceptable in space, and with regard to the ISS, you have 15, almost all of the major space powers, barring China, acknowledging that this is a valid principle with regard to protecting a state activity. This is defensible under precedent set in the high seas with regard to military activities there, which of course don't apply to the Moon, but I think there's an analogy between the military tests on the high seas and the permissible scientific activities that may be conducted on the surface of the Moon. For example, when a Dutch ship violated a French warning zone, the Danish government protested not to the French, but to Greenpeace for abusing the right of freedom of the seas. So these rights are not absolute. This is affirmed in UNCLOS and in the Continental Shelf Convention. You can have limited exclusion zones around specific assets. And so it is difficult, and there would probably need to be more factual findings with regard to who is correct regarding the actual harmful contamination.
Mr. Perry, is your Moon Protection Act, you consider that binding on non-Lydian personnel?
Well, Your Excellency, that's a complicated question because there is no prescribed enforcement mechanism in the Act except to come here and get a declaration regarding the equities of the case. We believe that it is inequitable for a state to enter a facility which includes, it indicates in the compromise, it doesn't give a specific number, but each exclusion zone is limited to 5 kilometers or less. And judging from the size of the exclusion zone around the facility, it appears that there's probably at least 40 distinct objects there. So you're really talking about a vast complex. So it's not really equivalent to being out on the open surface of the moon. Obviously, Lydios doesn't have an absolute right to regulate there, but there's an issue of interference when you have a state claiming to use an installation that Lydios has responsibility for as the watching state. In the specific context of the case, the activities are all being conducted using Fortuna.
Mr. Perry, what, if any, effect did your country's declaration of abandonment have on your ability to pass the Moon Protection Act and try and come to this court and ask us to declare a judgment on its effectiveness?
Your Excellency, with regard to Fortuna, the Moon Protection Act can be interpreted one of two ways with regard to Luna 1. It can be interpreted as an actual attempt to abandon, in which case it was invalid at the start. We have Manfred Lachs says the state can't get out of its obligations by abandoning the object. Lyle and Larson, noted publicists, indicate that a state cannot get rid of its responsibilities by abandoning, and then additionally...
Well, then what was the purpose of declaring an abandonment?
Well, I think the Act can be interpreted to simply give a temporary right of use. We know from the compromise that the reason that the facility was initially shut down was not any policy reason. It was because of an attempt, because of financial duress. So I think that based off of the facts, it appears that Lydios didn't have use of the ability to use their objects at the time, and so was offering other states the ability to use their objects. And we have several instances in the compromise, or certainly one in particular that's a dispute, where Lydios sold off some of its space assets because it believed that it didn't need them anymore. It sold off some property interest in those space assets, and it appears that it hasn't done that with regard to Fortuna. It hasn't done that with regard to any of the facilities there.
But you would agree, would you not, that by a declaration of abandonment, your country, Lydios, has forfeited some property rights? What property rights would those be?
No, Your Excellency. A temporary right of use is what we were contending was offered. Now, of course, if it was an attempt to abandon, it was simply invalid. There was a recent copious report which summarized the existing law on this. Even a non-functional installation, it cannot be abandoned.
Then, as a signatory to all the conventions, why would your country make a declaration of abandonment when you realized it was of no legal effect?
Well, Your Excellencies, I believe both states in this case have allowed an ambiguous jurisdictional situation to persist. Because of the presumptions established by the Registration Convention and the Outer Space Treaty, neither state for 5 years made any specific declaration regarding the legal status of Fortuna. The Registration Convention provides a presumption that the launching state is the state responsible. Likewise, the Outer Space Treaty provides that presumption. Now, we have state practice, which indicates states are not absolutely bound to that, or under Article 31 of the Vienna Convention, states are to take into account the subsequent state practice, and we have instances of states re-registering an object. This didn't take place in the case of Endymion here. They had several options available with regard to providing notice that they wish to assume jurisdiction. Knowing Endymion is a sophisticated actor in space, they had reason to believe that there are these presumptions in the outer space treaties. The launching state's responsible, and we know under Article 2, states can agree. Benching says this is not. There doesn't have to be specific notifications. States have a wide range of options with regard to agreeing to split up jurisdiction and control. States can give other states a temporary right of use, as Article 2 of the Registration Convention has been interpreted.
Where in any of the treaties does it address the concept of abandonment and then repossession?
Well, Your Excellency,
the assertion of what you're asserting here, which is some type out of the bundle of property rights. You seem to have abandoned some, but we're not sure which. But now you're asserting others, and we're not sure why. So, what is the legal basis for this argument?
Well, firstly, I think that actually strengthens my point because there's no specific provision. I think that the extra textual right to transfer space objects should be construed narrowly. Endymion had several ways. It had 5 years to give notice. It could have re-registered the object, as countries like Sweden and the United Kingdom have done. It could have made a declaration, like the Netherlands, which doesn't think it has to re-register objects that it buys from another state. It could have said, notified to the UN, we're assuming jurisdiction, but we don't have the responsibility to register. It took none of these avenues. The only possible way that they can defend their rights here, and I would argue the declaration was to the states party to the Outer Space Treaty. The principles on unilateral declarations of states indicate that reliance has to be justified. It doesn't appear to be justified in the present case, because you have a declaration to the states generally, of which Lydios is one, which strengthens the idea that there's no specific property right that Endymion has been given. The argument they could make, but it appears to be invalid, is that there was some sort of constructive transfer, but that seems doubtful first, because they had these multiple avenues that they didn't take, and the treaties have a presumption. Additionally, we have an international court case right on point. The Sududu Island case between Namibia and Botswana. One state had their tribes were on the island, and they were saying that kept the other state from making a claim to the island. The court found there wasn't any indication that that was prejudicial to the claims of other states. Here we have multiple parties who are trying to use the installations at Luna 1, and it's not clear that Endymion ever gave them notice, not just to Lydios, but to the other states who are making these preparations, that they intended to assume an exclusive right. And
excuse me.
Yes, Your Excellency.
I saw nothing in the cases laid out to me that Endymion was claiming an exclusive right to Luna 1.
Well, Your Excellency, under Article 6 of the Outer Space Treaty and under Article 8, there has to be a responsible state for the object, and it would create a chaotic jurisdictional situation. I think this is illustrated by the situation with Messenger 3. We have a national of the state buying it through a third party, and I think this illustrates why there has to be a clear state-to-state obligation. We have another court case in point, the Notbom case. The two parties, Guatemala and Liechtenstein. Liechtenstein issued a visa. Guatemala accepted it. So there was a little bit of government action on both sides. However, in that case, the court found that wasn't sufficient. There wasn't an intent to create a state-to-state liability. And so on that basis, it appears that jurisdiction for Messenger 3 has not transferred. And
Isn't Lydios stopped from saying anything about Endymion occupying, since you said nothing, your state said nothing, when the announcement was made and tourism started?
Well, the announcement was just of tourism. It wasn't of a claim of ownership, and you had multiple countries making such announcements. According to Anthony Ost, a noted publicist, if you're claiming another state has acquiesced, the nature of your own claim needed to be clear. The right you're invoking needed to be clear in order if you're stopping another state. And additionally, as per the Sududu Island test, there needed to be clarity and precision. Here, we have a previous case litigating territorial jurisdiction, the Clipperton Island case, where France got jurisdiction because they had passed an act which notified the world of their intent to make the claim. Endymion's passed no such act. And because of the lack of clarity and precision, we have to go back to the presumptions in the Outer Space Treaties, and the launching state is responsible. And for the aforementioned reasons, Your Excellencies, we ask the Moon Protection Act's validity be upheld with regard to activities around Fortuna and around Messenger 3. Thank you.
Thank you, Mr. Perry. Agent Phelps.
Mr. President, Your Excellencies, my name is Jacob Phelps. I represent the Republic of Lydios in today's proceedings, and I'll be discussing contentions 2 and 3. Lydios did not have an obligation nor an international duty to provide propellant for Kendeta's robotic space probes. When determining obligations and rights in outer space, the very first place to look would be that of the Outer Space Treaty. This is the treaty upon which all of international space law has been built, as I'm sure you are well familiar with. And in that text, there are many broad and general statements of responsibility and obligations, and the only one that it would appear to Lydios to have an application to this particular contention, that of a duty to render aid, would be that of Article 5. Article 5, Paragraph 2, most likely. And that is that one state party shall render all possible assistance to the astronauts of another state party. In this particular instance, it is quite simple. Kendeta is not a party to the Outer Space Treaty. The Bennu craft, a Kendetan craft, is not subject to the rights that flow from the Outer Space Treaty. I'm reminded by the words of noted international jurist Max Huber, who noted that responsibility is the necessary corollary of rights. In this particular instance, we have a country, Kendeta, that is claiming rights that flow from an instrument that they had the ability to accede to, yet chose not to. Out of all the major space treaties, the only treaty that Kendeda chose to be a part of was that of the registration and return, or excuse me, of the rescue and return agreement, the one that would most likely benefit a country attempting to become a launching state.
So if I can ask, Agent, under no circumstances would Lydios would have any legal obligations?
No, I wouldn't characterize it that clearly. I think there are a series of hypotheticals that could be created in which, under just general principles of humanitarian notions, that Lydios, an obligation might arise for Lydios.
So there are laws that could be at play here beyond the Outer Space Treaty.
Absolutely, absolutely, Your Excellency. And I will continue through not only the Outer Space Treaty, but the Rescue and Return Agreement, and even some analogies to maritime law. Specifically, as I stated, Kendeda is simply not a state party of the Outer Space Treaty. It would be inequitable and unjust to allow them to claim rights that flow from a document for which, to this very day, they still have not acceded to.
Agent Phelps, are you basically, you're arguing against a party who's not represented in this court? Endymion is. Are you arguing that there's no sort of bank shot or collateral ability of Endymion to claim in their own right for the indemnification?
Sure.
And they are a party.
Yes, indeed, Mr. President, and that's my next point, and that is Mr. Belippo simply isn't an astronaut. Mr. Belippo, as we know from the clarifications, is merely, quote, merely a tourist. I guess he was along for the ride. To assert that a nation could, its attendant responsibility, obligations, and rights could somehow be implicated by the whims of a tourist is certainly a position Lydios is not willing to make in international law, and I would assume Endymion would not be willing
so,
to make
Agent,
that.
is your position that some human beings in outer space are entitled to more protection than others?
Lydios asserts that there are some astronauts, some human beings, namely astronauts, who would fall under a very broad obligation to render assistance to under Article 5. However, if the situation was one, I would assume that you're alluding to, of an actual threat to human life, no, Lydios would not say that that line is drawn at astronauts, wouldn't be willing to. As a matter of fact, we would be more than happy to begin negotiation of a separate treaty regime to deal particularly with this tourist problem.
So if Mr. Belippo were properly understood to be an astronaut, would your position be different?
It wouldn't, because of the actual facts of this particular circumstance. Under the Rescue and Return Agreement, another document that, in this particular instance, all three of these states are party to, we find several obligations more clearly announced, and the term astronaut is then defined, as we know, as the personnel of a spacecraft. However, upon careful reading, just the face of the text, there isn't an article that directly applies to these facts. The closest we get is Article 3. However, if we take it in its full meaning and read the entire sentence that combines that paragraph, it simply doesn't apply to these facts. It talks about alighting on the high seas. Certainly there's no alightment of the Bennu craft. When the Bennu craft first made a request for fuel and to visit the Diana, it was en route to the Artemis. It was not alighting on the high seas or even alighting under a, quote, territory not under the jurisdiction of any state. I will state on this particular point, we know from the travaux regarding the Rescue and Return Agreement that this phrase, territory not under the jurisdiction of any state, is actually meant to refer to Antarctica. At the time that the treaty was being negotiated, multiple states had claims to Antarctica, and the easiest way, the most neutral way to refer to that particular body of land was to call it a territory not under the jurisdiction.
Agent Phelps, some of that background is useful, and as is the analogy to maritime law, but let me ask you, are you basically equating customary, let's say, maritime law, that if a ship were in distress, a vessel that went to its aid could say, we'll take the captain, the crew, but all you passengers fend for yourselves? Because that seems to be what you might be saying about poor Mr. Belippo here.
No, Mr. President, and that's certainly not the position of Lydios. And if the facts of this particular instance had been commiserate with that hypothetical you gave me, we certainly would not be having these proceedings today, because we would have rendered assistance. However, the facts that are actually presented in this case simply aren't that. We do know from, for instance, the Convention on Life Safety at Sea, that even at sea, even on the high seas, a captain of a ship has two modifiers to his duty. One, in the specific circumstances of the case, that's the wording from the Convention, if he's able and if it's determined to be necessary. Now, we find, amazingly enough, those exact same phrases within Article 3 of the Rescue and Return Agreement, where it stated that state parties in a position to do so, if necessary, shall render assistance. Now, again, it's in search and rescue activities, which certainly this was not the case, but you see the parallel between the maritime language, which allows, I think quite clearly from the facial text of the document, the captain who's called on to render assistance has some control over whether or not that assistance is even rendered. And in light of the facts of how the Bennu craft called for assistance, I think it's certainly within the realm of rational behavior of the personnel at Diana to not render this propellant that was needed for a robotic probe. First off, Kendetta had no diplomatic relations with Lydios whatsoever. As a matter of fact, Lydios had complained.
I'm confused by the propellant for the robotic probe. Did they not at one point say to the person who was in charge of Diana, this is a matter of safety and urgency?
Yes.
Well, it had nothing to do with probes. It had to do with the people that were on that ship, correct?
Yes, Mr. President.
Okay, so how does that fit into the argument you're making that they don't have to give fuel for probes? I can see where that could be a good argument, but what about once the declaration of necessity and need and life is made? Who decides and how and under what principles?
Again, I would point it back to the analogy in maritime law. That language was then mirrored within space law in those treaties, that ultimately the captain whose assistance is requested from still maintains an ability to modify that duty if able and if necessary. And in these particular situations, Lydios, for one, arguably is certainly not able to provide this assistance. We made it known to the world very clearly almost a year ago to the date that this incident has happened, that the entire Luna 1 facility would be decommissioned, mothballed, shut down. And Diana was to remain open until the very end, arguably, to provide the resources needed to facilitate that shutdown.
Would you agree that if the decision had been made by Diana that they would render assistance, that it in fact could have been rendered with fuel aboard Diana?
I think factually it perhaps could be. But in addition to that, we have the if necessary, and even in general principles in maritime law, we know that a captain who's called on to render aid has to balance the safety and life of his crew and his ship against this request for aid. And we certainly have, I believe, a pretty strong position Lydios does in that regard. We have
What balance was done in this case by the person who refused?
Well, we just know.
Sure.
We know that Lydios does not allow any of its entities to launch from Kendetta. It doesn't allow them to use Kendetta craft.
I understand that. I'm talking about the safety argument you're making.
Yes.
What balancing, if any, was done to refuse to provide what was pretending to be a safety issue?
Sure. The only facts I can point you to, unfortunately, from the compromise that we have is that the Kendetta space program has a 2-to-1 failure rate, and that this was the second successful mission ever of the Bennu craft on that particular day.
So,
prior to that, it erupted in a ball of flames.
Agent, are you saying that Lydia was able to determine without question that health and safety was not at issue when the request for assistance was made?
I think what Lydios is asserting is that in the moment, the captain, the officer, the Lydian national at Diana made the best decision she could make with the information she had. She knew Kendetta and Lydios didn't have diplomatic relations. She knew that Kendetta had a terrible, horrifically bad track record, and to dock with a facility that was being shut down, again, going back to these mitigating circumstances of the duty that's acknowledged in admiralty law and ultimately, I think, in space law, she made the decision that it wasn't necessary and she wasn't able to provide that assistance.
So if someone's life is at stake, does the nature of the diplomatic relations associated with the country he comes from matter?
No, Your Excellency, it doesn't. But however, taken in context of all of the totality of the circumstances, that may be one contributing factor to a captain determining that it wasn't necessary or that they were unable.
So you believe that it was reasonable for the captain to make the determination that she had sufficient information in front of her that life was not at issue here?
I think the fact that proves this out the most is the fact that there wasn't a life safety issue. I mean, certainly the proof that she was reasonable is in the actual result, that there was never a life safety issue.
So does that make for good law or just dumb luck?
I think what it is a reaffirmation of the principles that have been set down for hundreds of years in maritime law and then modeled in space law, that in those situations the captain has to weigh the safety of her crew and her ship, as well as the ability of it to provide that aid before it renders it aid. And that is what the Lydian official did in that instance.
Did she have sufficient information to make that decision?
I think that she did. Yes, she did. From the information available, she did. We know that the Bennu craft was still under propulsion, was able to maneuver. It had multiple options, which I would like to move to the third contention when we're finished with this conversation. But ultimately, we know from the facts that they were able to do several things. They were able to attempt to dock at Fortuna. They certainly had enough propellant. I would draw the bench's attention to two critical facts. One is that it was a very small propellant leak. That's from the compromise. It was repaired prior to all of this occurring, and no fuel was ever transferred from the Bennu craft, which would have created a life safety issue, to the common probe. The Bennu craft had sufficient propellant to do a bunch of things. It could have returned to Earth. It could have gone straight to Artemis, the actual mission destination. And it's this series...
This wasn't known by the person who made the decision about Diana, though, was it?
No, it wasn't, but I'm illustrating these points from a liability standpoint.
And I think it would be good if we did move on and give you an opportunity to address the third issue you'd like to address.
Sure. Thank you, Mr. President. It is this, ultimately, the contention 3 is to determine liability. And in this particular instance, we do have an entity that's liable. We have one entity that we can point to, and it's the Bennu captain that we can point to that's ultimately liable for the failed deployment of these probes. From the very first moment he discovered this small propellant leak, he had a series of options available to him. He could have returned to Earth. He could have continued to his mission destination. He could have proceeded on to the Fortuna object that Endymion was trespassing on. However, he chose the most convenient, the closest navigable point. His first comment wasn't an SOS, it wasn't an emergency distress comment. It was, can we visit and obtain fuel? No. Can we visit and my government will pay for the fuel and you can even come on board our ship? Well, because it's for the life and safety of our crew. He never clearly articulated that he actually was in an emergency situation. And ultimately, under the liability convention, which I think is the closest thing we could use to determine fault or to determine liability here in this particular instance, we have a fault-based system. When two space objects interact, we use a fault-based system. We have to find a negligent act, some proximate causation for the actual failure. And here again, it's in the facts. The Bennu captain, when he couldn't make the seal with the Fortuna docking mechanism, instead of stopping, he again made a bad decision. He continued to press his advantage, to attempt to press his advantage by continuing to attempt to dock until he broke the docking mechanism of the Bennu craft. That's what ultimately doomed this mission, that ultimately led to the failed deployment. We know from this court just last year when it reaffirmed its principles, when you're determining an injury and connecting it with a wrongful act, there has to be a direct and certain causal nexus between those two things.
And Agent, you don't think that the manufacturer of that docking system has any liability or responsibility in this case?
Well, we know Carl Crystal's made this clear that there isn't really a standard of due diligence or a standard of care that's been established in outer space activities. However, Lydios is certainly of the opinion that this particular object, Fortuna, is at least, I see that my time has expired. May I conclude my
Please finish that thought.
We know that the Fortuna space object is at least 20 years old. To set that standard of care to maintain a fluid's life beyond 20 years seems unreasonable.
Just one question, yes or no. If Mr. Filippo had died because there was a failure, Endymion is a signatory to all the treaties. If the refusal to refuel that craft were the direct result of Mr. Filippo dying, would Lydios be liable?
The injury doesn't change the outcome. It doesn't. There weren't circumstances to lead to that. If the circumstances were different and he died, then yes, but not with the facts we have before us. No.
Okay.
Thank you.
Thank you very much, Mr. Phelps. Agent Krause.
Mr. President and Your Excellencies, may it please the Court. My name is Amanda Kraus, and together with my co-agent, Adam Wazalowski, we represent the Republic of Endymion, the respondent in this matter. I will address the first and second issues of the submission in 16 minutes, while my co-agent will address the third issue in 12 minutes. I would like to reserve 2 minutes for rebuttal.
Great.
This case is about a state violating some of the fundamental principles of international space law: free access to outer space and concerns for human safety. First, Lydios violated its obligations under the Outer Space Treaty when it enacted and attempted to enforce the Moon Protection Act. And second, Lydios breached its duty to rescue under both the Outer Space Treaty and the Rescue and Return Agreement when it denied the Bennu docking privileges at Diana. I will begin with the first issue regarding Lydios' promulgation and attempted enforcement of the Moon Protection Act. The enactment of domestic legislation can constitute a violation of international law when the content of that legislation is contrary to what is required by an international obligation, and this is indicated by Article 12 of the Draft Articles on State Responsibility, which this court has recognized as a statement of customary international law in the Gabjakov-Nagimaros case. The enactment of the MPA violates two principles under the Outer Space Treaty. First, the principle that stations on the Moon should remain open to representatives of other states' parties under Article 12, and second, the principle of free access and non-appropriation under Articles 1 and 2. Beginning with Article 12. Article 12 of the OST states that all stations, installations, equipment, and space vehicles on the Moon and on other celestial bodies shall remain open to representatives of other states' parties to the treaty on a basis of reciprocity. And the drafting history of this article indicates that it was not intended to grant a veto right for access. The MPA, however, does create this veto right. The drafting history makes it clear that the only limitation over this right to access is for that of endangering the lives and safety of those on the station. Paragraph 20 of the compromise states that the MPA requires prior approval of...
And I'm sorry, Agent, and you think that there was no issue of endangerment in this case to the personnel on the station?
Your Excellency, the violation that is alleged in this case of Article 12 is simply the enactment of the MPA, which grants Lydios the right to veto access in future attempts to visit the lunar station. And the MPA does not condition this right to access simply pending international consultations or preparations, but rather states that any time a state would want to visit the lunar facility, it would require Lydios' prior consent, which does give Lydios the right to completely deny access to those stations in contravention of this article. And turning to the second principle, OST Articles 1 and 2 require free access and non-appropriation of the Moon, respectively. And working together, these two articles make it clear that because no individual nation can exercise preeminent authority over any area of the Moon, it cannot deny access to that area. Article 1 states that there shall be free access to all areas of celestial bodies, and Article 2 states that outer space, including the Moon and other celestial bodies, is not subject to national appropriation by claim of sovereignty, by means of use or occupation, or by any other means. And given its ordinary meaning, as is required under the Vienna Convention on the Law of Treaties, Article 31, appropriation simply means a taking of possession, and sovereignty means to exercise supreme authority. Paragraph 20 of the compromise tells us that the MPA creates 1 to 5 kilometer buffer zones that are meant to exclude others from certain designated areas on the Moon. And in essence, the Act draws territorial boundaries requiring Lydios' consent to enter, akin to a national border on Earth, and as such constitutes an attempt to appropriate those areas. In other words, Lydios has attempted to exercise supreme authority over who can and cannot enter certain areas of the Moon, in contravention of the free access and non-appropriation principles under Articles 1 and 2.
Agent Krause, the MPA would be valid as against Lydian citizens, correct?
Your Excellency,
They can forbid their own citizens with the MPA.
Your Excellency, it's unclear if the MPA could prevent even Lydian citizens. However, it's clear that the MPA, as stated in paragraph 20 of the compromise, is intended to bind all other nations, not just Lydian nationals. And I should note that current state practice recognizes the importance of abiding by Articles 1 and 2 of the OST. NASA of the United States government recently passed guidelines that recommend certain buffer zone areas around the Apollo landing sites and other United States equipment on the moon. But the NASA guidelines are admittedly not legally binding, even over U.S. nationals, let alone over other states' nationals, because the U.S. government recognized that its treaty obligations under Articles 1 and 2 of the OST trump the buffer zone interests.
So, Agent, your argument would be a foreign country could come in, utilize, take, or destroy, or otherwise harm the Apollo sites, and there would be no legal repercussion?
Your Excellency, while there may be legal repercussions to stay out of certain areas, that is a separate issue than attempting to appropriate a certain area. For instance, of course, every state does have an interest in having a certain buffer, a clear zone area around their equipment. However, if another state does come too close to that, then that's simply that violating states, or that action would be a state violating Article 9 obligations of due regard and harmful interference. There is no indication that a state, or actually, it's clear that Articles 1 and 2 do not allow, of the OST, do not allow a state to appropriate areas around their space objects. I'd like to turn to the second issue regarding Lydios's failure to allow the Bennu to dock at Diana. When Lydios failed to open its dock to the Bennu, it violated one of the fundamental principles of international space law, which is that activities in outer space should be conducted in consideration of the welfare and safety of astronauts. Specifically, Lydios's conduct violated two of its treaty obligations. First, Article 5 of the Outer Space Treaty, and second, Article 3 under the Rescue and Return Agreement. And beginning with Article 5.
Excuse me, Agent Krause, would it have made any difference if instead of the Bennu ship's captain, Mr. Bilippo, a citizen of Lydios, had made the request and said, I'm an astronaut from Lydios, from Lydios, and from Endymion, and I'm making a request because my life's in danger.
Sorry, no, Your Excellency. The request from Mr. Bilippo would not have made any difference. And contrary to Agent Office's proposition that Mr. Bilippo is not considered an astronaut under outer space law, it's clear that given the drafting history and the object and purpose of Article 5, as well as the Rescue and Return Agreement, this humanitarian concern for safety should not allow the court to limit the use of the term astronaut simply to the specific personnel on board the spacecraft. Indeed, that would result in an absurdity in the sense that Lydios would only have an obligation to rescue the personnel and leave any tourists stranded alone in outer space. Turning to Article 5. Article 5 of the OST states that in carrying on activities in outer space and on celestial bodies, the astronauts of one state party shall render all possible assistance to the astronauts of other states' parties. And the duty under this provision is incredibly broad and has been stated to be merely a logical extension of basic morality. And especially in light of the broad language of this provision, Lydios' obligation at the very least encompassed the duty to open its port to allow the Bennu to refuel at a cost that would have been repaid by the Kingdom of Candida.
So you believe there's a legal obligation to support the successful implementation of commercial interests? Is that the argument, Agent?
No, Your Excellency. Contrary to that, paragraph 23 of the compromise states that when the Bennu requested refueling from Diana, it stated explicitly that the refueling was needed for the lives and safety of the personnel on board the spacecraft. And clearly this provision falls under that obligation.
So all someone has to do is use those magic words, and it doesn't matter whether there's any truth behind it?
Well, Your Excellency, when a state does put out appropriate distress signals, we should not allow states to simply second guess that appropriate distress signal. And we should consider, again, the alternative, in that if we allow states to simply second guess and say, what if they are lying, then what if there was a loss of life in the spacecraft? When the commander of the Bennu stated that the refueling was necessary for the lives and safety on board, the duty was very clearly triggered at that point. And turning to Article 3 of the Rescue and Return Agreement, Article 3 requires contracting parties to assure the speedy rescue of personnel of a spacecraft under certain circumstances. First, the party must receive information of the need for rescue. Second, the personnel of the spacecraft must have alighted in a place not under the jurisdiction of any state. And third, the contracting party must be in a position to render the assistance. Additionally, this duty under this provision is incumbent on a party regardless of the cause of the incident or the availability of alternative locations to attempt to land. Lydios clearly did receive information that the Bennu was attempting to land on the moon and was in need of assistance, as indicated in paragraph 23 of the compromise. The duty to render assistance was triggered at this moment. Additionally, the Bennu was alighting to the moon. It was descending from the air in an attempt to land there. And
Agent, requesting docking was enough, in your mind, to open the ports and to receive the ship. Just that request.
Well, no, Your Excellency. The request to dock when it was stated that it was needed for the lives and safety of the personnel on board the spacecraft.
So only at that point.
That's correct, Your Excellency.
And why wasn't that the first request made by the captain?
Well, with respect, Your Excellency, problems in outer space can, of course, develop very quickly. And one moment, the commander of the Bennu may have thought that the mission was completely fine and that they just wanted to ensure the commercial success and to be able to launch the Comet probes. And maybe only a moment later realize the dire need for additional fuel to complete the mission.
Should it in any way affect the decision of this court that it appears, since everything turned out just fine, that should have an effect on our decision, the truthfulness of the commander of the Bennu?
Well, no, Your Excellency. That does not change the duty at the time this rescue would need to be rendered. As Your Excellencies pointed out, the commander of the Diana had no way of knowing whether or not the lives and safety of the personnel on board the spacecraft were actually at risk. And we should not be letting states to second guess that distress signal. Indeed, it's important to look at the drafting history of these conventions. And this was at a time when the United States and the Soviet Union were in the Cold War. And even they were willing to say that they would render all assistance to each other in outer space in the event of distress.
But we're a long way from the Cold War, Agent. Do you think under this new commercial scenario, if we rule wrongly here, are we opening up the situation for abuse where, as His Excellency said, you use the magic words and you can get out of otherwise commercial obligations to carry enough fuel? Do you see potential for abuse here?
There is potential for abuse here, Your Excellency. However, I have two responses. First, the court should consider the alternative in allowing states to second guess appropriate distress signals. And secondly, even if there was an abuse, then the abusing party would simply have to make reparations. And even here, Candetta did make it clear that they would repay for the cost of the fuel when they docked at Diana.
Should that be the extent of the Beppu captain's liability here for intentionally misrepresenting the facts?
Well, Your Excellency, again, that is not the issue before the court. What is here is the fact that the Bennu had requested refueling for the lives and safety of the personnel on board the spacecraft. And Lydios did have a treaty obligation under both Article 5 of the OST and Article 3 to render this assistance.
Okay, Agent, are you seeking a declaration that, yes, Lydios had an obligation to fuel, which is totally separate from, yes, Lydios now has an obligation to make somebody whole, Endymion, Candata, whoever?
Your Excellency.
I'm trying to noodle through what exactly do you want this court to do? Make a declaratory judgment that once you declare an emergency, whoever refuses to help you has done something wrong, versus whatever flows from that, even if no harm flows, somehow we've got to indemnify for mission success?
No, Your Excellency, this is not, the separate issue of damages, of course, will be addressed by my co-agent. However, just to quickly respond to your question regarding the duty under these articles, under the issue 2, we're simply requesting that the court declare that there is an obligation under these circumstances, and when there is an appropriate request for distress, to simply give more clarification to these treaty obligations to make it clear that a state cannot second guess appropriate distress signals.
Agent, you've used the term appropriate. distress signal a few times now. Is there any significance to the word appropriate? What makes it appropriate or not?
Well, certainly, Your Excellency. Simply the fact that this was stated that it was needed for lives and safety of the personnel, and and considering the humanitarian concern behind both Article 3 of the Rescue and Return Agreement and Article 5, that signal itself is appropriate.
Agent, briefly, how should this court balance the issue of potential threat to the personnel on lunar surface versus the needs of a visiting craft?
I'm sorry, Your Excellency, could you repeat the question?
So let me ask this. Do you believe that there was any legitimate cause for concern by people on the moon for damage if they allowed the docking to occur?
If the Lydian operators might have a concern?
Yes.
Of course, Your Excellency, that every rescue mission on the moon or in outer space is not riskless. And Article 5 makes it clear that a state... Oh, I see that my time has expired. May I
Please
finish this
continue
thought?
that thought.
Even though a rescue mission is not riskless, there's no indication in the compromise that this actually was a risk to Lydios. They simply outright denied the request when it was stated that it was needed for the lives and safety of the personnel. Thank you.
Thank you.
Mr. President and Your Excellencies, may it please the Court. My name is Adam Wasilowski, agent for Endymion, and I will discuss the third issue in 12 minutes, that Lydios is liable for damages due to the failed deployment of Candetta's twin probes. And there are two issues to discuss today. The first is that indemnification is proper in this proceeding, and the second is that Lydios is liable under customary international law because it is at fault for the loss of the twin probes. So turning to the first issue, that of indemnification. It's important to remember that Candetta is bringing its own separate parallel action against Endymion for the loss of the twin probes. And so Endymion is merely before the court today to ask that if damages are awarded in that separate action, that Lydios be liable to pay them because it is actually responsible for the loss of the twin probes. This concept has been recognized in customary international law, as the International Law Commission's draft articles on state responsibility, Article 47, have recognized. So turning to the crux of the matter, which is that of Lydios' liability under customary international law because it's at fault for the loss of the twin probes. In customary international law, a state is liable to make reparations in the event that damage is due to its fault. And under this standard, there are three prongs that must be satisfied. The first is that of attribution, the secondly is that of breaches of international obligations, and the third and final prong is that of causation and damage. Turning first briefly to the prong of attribution. There are two acts or omissions here that Lydios undertook that led to the damage. First, Lydios denied docking privileges to the Bennu craft, and secondly, it negligently manufactured the faulty docking mechanism at Fortuna, as compromise paragraphs 23 through 25 indicate. So then turning to the second prong, which is that of breaches of international obligations. Lydios here breached two sets of international obligations. It first breached, as my co-agent discussed, its international duty to provide assistance at allowed docking under OST Article 5 and the Return and Rescue Agreement. And it secondly breached its obligations of due diligence because it had an obligation to allow visits by other states to the space station under OST Article 12. Contrary to Agent Opposite's assertion, there is a standard of due diligence and an obligation under customary international law.
Agent, may I ask you a question because I'm confused, which happens often. What's the basis of Candetta's claim against Endymion?
Your Excellency, it's possible that Candetta brought its separate action against Endymion because Endymion...
The legal basis for its claim.
The compromise is silent on what Candetta is advancing in that separate proceeding. It's possible that their theory is that because Endymion was in control of the Fortuna mechanism at the time, that would be sort of a place where they could go to achieve damages. But The real obligation here is the obligation of due diligence on Litios to have manufactured the mechanism properly in the first place, and that's where the court's attention should be focused.
So you're basically asking this court to declare that whatever the basis of Kendata's claim, Endemios is totally off the hook and it's going to be indemnified. That's what you're asking the court to say.
Yes, Your Excellency. The court, the Endymion here is here before the court today to request that it was actually Litios' fault that the damage occurred to the Comet Probe is because of the breach of international obligations.
Let me get to that point. If I understood right, when all was said and done and the Kendata spaceship returned to Earth, the probes were just fine. One of them had a leak, but basically nothing was destroyed. They could be launched again. So what damage are we talking about here?
Well, again, Your Excellencies, that would be dealt with in the separate proceeding between Candetta and Endymion, but it is important to note that this court has recognized consequential indirect damages can be awarded, such as in the Chorzow factory case, where the predecessor to this court decided that lost profits could be awarded after the Polish government seized the German government's factory on its territory. So there is a basis in international law for the potential types of damages that would have been awarded in that separate proceeding. But returning to the obligation of due diligence as a breach of international obligations.
Agent, before you go there, before becoming a judge, I used to work for a commercial space company. And do you think that there would be any chilling effect on the investment of companies and countries in lunar infrastructure if we rule in your favor and extend out this legal obligation that you're arguing for?
No, Your Excellency, because the compromise is clear that this was Litios' construction of the faulty docking mechanism at Fortuna. Compromise paragraph 23 through 25 state that it was Litios who constructed this docking mechanism. If a private entity was contracted out to build this mechanism and manufacture it, then perhaps there could be a separate indemnification arrangement contractually that could occur between that private party and the state. But under the Outer Space Treaty, states under Article 6 take national or international responsibility, for their national space activities. The compromise is clear here that this was a national space activity of Litios, and for those reasons it should be held liable because it breached its obligation of due diligence, which requires under international law, first, that a state take appropriate measures under the circumstances to, secondly, meet its international obligations. And Litios breached this standard of due diligence when it negligently manufactured and constructed the docking mechanism on Fortuna by using the wrong fluid, as compromise paragraph 23 indicates. It knew how to properly manufacture these docking mechanisms, as compromise paragraph 25 indicates, and therefore it was appropriate under the circumstances that Litios had this knowledge and should have constructed a properly working docking mechanism. And it's also an obligation of due diligence because it would have been appropriate for Litios to ensure that its mechanism worked properly, both because it had an obligation under Article 12 of the Outer Space Treaty to allow visits by other states to the space station, but also because it licensed this docking mechanism to other states.
Did it have any obligation to Kendata for building a jackleg docking mechanism? I mean, once Kendata builds a jackleg docking mechanism without paying the licensing fees and without any indication that they've in fact followed the instructions, does that still mean Litios is responsible for any consequential damage?
No, Your Excellency. There's not a concept of a clean hands doctrine as an equity principle that's been recognized in this court. This proceeding has been presented to the court to be decided under the basis of law, not as an ex aquio et bono matter, as the International Court of Justice statute prescribes. The parties have not agreed to it. And it's important to remember that the due diligence obligation here was imposed on Litios at the time that it constructed the mechanism. It had the knowledge to do so properly. It was the least cost avoider in constructing the mechanism, and it breached this duty by not negligently using the wrong fluid. So then I'd like to turn to the final prong of the analysis, which is that of causation and damages. And under customary international law, the causation standard is one of objective foreseeability, or would a reasonable person believe that their acts or omissions could lead to harm. So what did Litios know in this case that made it foreseeable that its breaches would lead to harm? It knew 5 facts. It first knew that the Bennu mission would launch comet probes, as compromise paragraph 17 indicates. It secondly knew that the BANU needed fuel because it requested refueling, as Compromise paragraph 23 indicates. And thirdly, it knew that the BANU would have to go somewhere else when that refueling assistance was denied. Fortuna was the only other option at that point, as Compromise paragraphs 15 and 24 indicate. It fourthly knew that states were going to be visiting its space station potentially because of its obligation under Article 12 to provide for this right of visitation. And it finally knew that it was important that these mechanisms work as they were intended, both because of this Article 12 right and because of the Artemis operating agreement, where they were licensing this design to other parties and were making a representation that it was going to work properly. So it's foreseeable that when a ship requests refueling and it's not able to refuel, that potentially the mission could fail and you could have economic and property damage. And it's also foreseeable that a ship that docks with a faulty docking mechanism could potentially be harmed.
Is that the real test, this continuing string of foreseeabilities, possibilities versus probabilities? Are you arguing that the foreseeability of this is critical in our decision?
Your Excellency, the causation prong is one of the elements of the fault-based liability standard under customary international law, and the International Law Commission has recognized that a standard of objective foreseeability is appropriate. It's also appropriate as a policy matter in this case because we want states to ensure that they take due diligence in conducting their activities in outer space. We want them to ensure that they construct that they construct their docking mechanisms to work properly, and therefore it's appropriate to impose liability on Lydios in this case if in the separate action damages are awarded to Canada.
Is Lydios stopped from saying they're responsible for it, even though they made a declaration that the whole world understood, apparently, that they were abandoning this? They were abandoning Fortuna?
No, Your Excellency. The issue here is that Lydios, the obligation for Lydios to show due diligence to other states was incurred at the point that they built the docking mechanism. So that's when the obligation kicked in for Lydios, and they breached this mechanism, they breached this obligation when they negligently failed to construct the mechanism.
Agent, are you suggesting that we should rule that whenever a party builds an object and places it on the moon, that party is forever responsible for that object, regardless of abandonment, regardless of use?
Your Excellency, Endymion here is submitting that a state, in undertaking its activities in outer space, act with due diligence to ensure that other states are not harmed by their activities. Lydios knew that other states, or knew that it had to offer its docking ports to other states under OST Article 12, and it knew that the docking mechanism had to work properly, both because of that right and because they were licensing this design to other parties. They were making a representation, and for that reason, Lydios should be found liable. I believe I've already discussed...
So, Agent, there are no limitations that you see that this court should consider in terms of that liability remaining forever?
No, Your Excellency. There are certainly limitations potentially on liability. The due diligence standard itself provides a limitation when it says that states must take measures that are usually undertaken under the circumstances. If there was evidence in this case that all mechanisms would wear out over time and potentially degrade, then perhaps the case would be different. But the compromise is very clear that this was a manufacturing defect that occurred at the point it was constructed, that if the mechanism was designed or was manufactured properly, that it would work indefinitely.
Let me ask you a question, just a hypothetical. If when they announced that they abandoned it, they said, we are no longer maintaining our docking ports on Fortuna, in fact, we're going to go up and smash them, would they still be liable? And to go back to His Excellency's question, are you forever liable even when you say, I've abandoned it? Are you forever liable for maintaining it in a functional order?
Well, Your Excellency, it's also Endymion's position in this matter that jurisdiction and control of at least part of the Luna 1 facility was transferred to Endymion in this matter. But I see that my time is up.
Please complete your thought.
The point is that the obligation of due diligence is imposed at the time that the mechanism was constructed, and it's appropriate to assign liability there. Thank you.
Thank you. Mr. Perry, is it your rebuttal?
Yes, Your Excellency. Your Excellency, the absolute obligation to give fuel has already been rejected in the UN principles on cooperation and sharing of benefits in space. It specified that has to be on a mutually acceptable basis, and this reflects state practice in this area. With regard to their operation of the docking fluid, it specifies that it degraded over time. Under the home missionary case, a state is not responsible for acts done in defiance of its authority, and under the principles on remote sensing, an operator can be liable. And so in this case, we have a defiant operator operating it until it finally reached the point where it broke at the particular point concerned, as the causal chain is breached. With regard to the Gopjakova case,
The defiant operator was Endymion?
an operator can be the person, it can be a factual analysis, because states have the ability to apportion an operation without giving jurisdiction. In this case, they were under home missionary, they were defiant, they were rebelling against the authority, so to speak, of Lydios, and Lydios can't be liable for their act until Lydios has the ability to reassert factual control. Now, with regard to the claim about illegal acts, the Gopjakova case actually specifically specifies that there's a distinction between preparation and an illegal act. In the arrest warrant case, it tied the illegality of a preparatory act or a preparatory act of state to the actual enforcement mechanism which was specified in the warrant, which was at issue in that case. And so here we have no enforcement mechanisms, and so the precedent of those cases supports Lydios' position that there's no breach. With regard to Article 12, in the Travaux Préparatoire, it was specifically rejected that there was an absolute obligation to let other states visit. This was one of the conditions on which the treaty was actually signed. Thank you, Your Excellency.
Thank you very much. Agent Cross?
Mr. President and Your Excellencies, may it please the Court. I will quickly address two issues just raised by Agent Opposite on his rebuttal. First, regarding the degrading of the fluid in the docking mechanism at Fortuna. Paragraph 25 of the compromise clearly states that the failure of the docking mechanism was caused by the use of the wrong fluid in a sealed canister in the hydraulic systems of the docking mechanism on Fortuna when it was constructed by Lydios. And as my co-agent clearly addressed, the duty of due diligence should be incumbent on a state at the time that the space object is constructed and that it is represented that it would work properly for other states to use. And additionally, regarding Agent Opposite's proposition that the MPA is not a violation of international law because there's no enforcement mechanism, it's very clear that Lydios has attempted to enforce the MPA against other states, and in doing so, it had demanded that Endymion vacate the lunar base, and very clearly has not just enacted this as a policy statement, but deems their domestic legislation to be a statement of international law that binds all other nations, clearly in contravention of its OST obligations. Thank you.
Thank you. Well, the arguments were fascinating. No, they were excellent, and you were all excellent, and the court will close for deliberations.
Okay, at this time, if all of the spectators can go ahead and leave, and you can go to the 12th floor of the Rose Building, you'll be escorted over. Student teams can stay. We're going to get your pictures taken with the judge right now. Okay? And then you'll leave. So, what do you think, having the judges down here? I think the best way to
Awesome. Part of my sweat. Oh, yeah. So what am I going to say? I will. I find that if I have my notes, I'll look at it, and I just can't. Thank you, sir. Appreciate it. Yeah. Thank you.
So this is kind of like the wedding pictures, okay? We'll start with the whole wedding party, so the three judges in the background, and then one team to this side, the other team to that side. I don't care which team is which. So we'll get everybody in first. Can you get that wide?
Actually,
Okay, it's in German, yeah. Okay. This is like a wedding party.
Yes, it is.
Yeah. It's cheap. Okay. Yeah, much.
Already to that.
it depends on what you decide. Okay, got it. 1, 2, 3. Use a flash, since now I can use a flash. 1, 2,
let's get the judges with this team.
Okay.
And then get the judges with that team.
One person.
Okay, all right, yeah, this actually makes more sense.
There you go. Smile, 1, 2, 3. One more. 1, 2, 3. Okay. And
Okay, next team.
Now, the brides?
Family of the bride.
How are we doing? We want to squat down?
Yeah, sure.
No, that's fine. Great. Good.
no.
I really want to
We'll just do the 3 judges in the middle.
Okay. And we're just stuck over here?
Yeah.
Perfect.
One
He just wants to make sure his cowboy boots are
Yeah.
Okay.
Smile. One more.
Yeah.
1, 2, 3.
Okay, all right, students, you can go over to the 12th floor. I'll be with you in a while.
Okay,
guys, great job.
It's a lot of fun. So much fun.
Wonder if we could go with
Oh, yeah, thank you.
Maybe a couple more rounds.
Thanks so much for putting this all together, and we're just doing this.
Thank you so much.
Yeah,
Thanks for getting your emails from us. To put a face to the email address.
No, we already do that.
You say yes or something?
Yeah, okay, so let's see.
I was about to be a...
That's fine. I actually wasn't deciding if I was going to.
Yeah.
What? Oh, yeah, this is all... Yeah.
I thought you guys would like argue about something that you don't have to do.
No, this is all...
Okay, so you guys can relax.
Yep.
Take off.
Yeah.
Good call.
And I'm going to suggest that we, well, you know what? My only concern about deliberating in this room is that we're still on. So, AV, just make sure you turn it off at the end of the program and not include this.
Yeah, we should be able to send.
So, I
If you prefer, maybe we could move to a room closer to the direction that we're
we
headed.
can simply go back to that 5th floor conference room
okay,
and we'll do that.
That sounds
Let's
fun.
do that. And let me